Good morning, everyone, and welcome to our Prestige PEO webinar series. My name is Shannon Shaw. I am Operations Supervisor at Prestige PEO and your host this morning. Today's presentation will begin with a brief introduction from Chip Ramsey, Director of Sales at Scout Logic, the premier background check partner of Prestige PEO, and our guest speakers, Robert Sibba and Pamela Devada, both partners at Seyfarth Shaw LLP, will review the laws that regulate background checks in New York. As a reminder, our webinar viewers are automatically muted, but we encourage you to utilize the chat feature for any questions you may have, and we will address them at the end of the webinar if time allows. If your question is not answered, we will follow up with you shortly after the webinar concludes. And if you need immediate assistance, contact information will be provided in our conclusion slide. The webinar is also being recorded and will be posted on prestigepeo.com/webinars page so that you can refer to it at any time.
Well, good morning, everyone, and I'm so excited to continue talking about Prestige PEOs and Scout Logic's continued partnership. For those of you who weren't able to be on the last webinar, Scout Logic is a full-service background check company helping Prestige clients through our service-forward approach. We help small and mid-sized businesses work more efficiently to get on board, so you guys get on board great talent. And with our Scout model, your dedicated Scout operates as an extension of your team. And they'll work directly with you and your candidates to acquire documentation, monitor your background checks, and give you proactive updates so you don't have to chase down the status of an open report. And we take compliance very, very seriously, meaning that you won't have to worry about anything legal and you can spend your time focused on finding your next great employee. And if there's anything I can do or we can do to help with your background check process, please reach out to us at any time. And now I have the distinct pleasure to introduce Pam and Rob, who will tell us about the laws that affect background checks in New York and things you should always keep in mind. Pamela Devada is a labor and employment partner at Seyfarth Chicago, in Chicago, Illinois. Pam leads Seyfarth's nationwide background screening, litigation, and compliance team, and is a national authority for all issues related to the Fair Credit Reporting Act, background screening compliance, use of criminal and credit history, and electronic signature issues. A nationally recognized employment counselor, Pam has participated in numerous interviews, speeches, webinars, and trainings to employees on the subjects of criminal history and credit checks, and has leveraged her niche area of expertise into a thriving class action practice. She represents employers, resellers, and consumer reporting agencies of background information on compliance requirements under the FCRA, develops procedures from appropriately handling high-volume national hiring needs, and regularly litigates these issues on a single plaintiff and class-wide basis throughout the country. She's also certified Lean Six Sigma Yellow Belt and was formerly an adjunct professor of legal writing at Chicago-Kent College of Law. Rob finds practical solutions for clients facing litigation and various business challenges related to their workforce and guides employers operating in New Jersey, New York, and nationally through the nuanced requirements for hiring, compensation, retention, and separation of workers in a variety of industries. He advises clients on a wide range of issues under federal, state, and local laws, including background check and FCRA violations, ban-the-box issues, prevailing wage requirements, wage and hour and overtime compliance, whistleblower retaliation, FMLA compliance and interference retaliation claims, paid sick leave, and a wide range of discrimination, harassment, and retaliation issues. Drawing on a decade of litigation experience, Rob strives to attain practical and efficient solutions that fit the client and meet the particular needs of the business. He collaborates with clients to find technological solutions to streamline the disruptiveness of litigation. Rob is listed in Woodward and White's Best Lawyers in America for Employment Law and listed in Thomson Reuters New York Metro Super Lawyers for Employment Litigation. So with that, welcome Rob and Pam.
All right. We are going to talk today about our agenda. What we are really doing here is trying to talk a little bit about some of the new laws that are happening in the world of background screening, with a particular emphasis on New York and New York City. Today, we're going to talk about the background check under New York and the Fair Credit Reporting Act, specifically relating to New York State and New York City together. We're going to try and give some best practices as well, and we will go from there. Without further ado, let's go ahead and dive in, and we'll go ahead and go again to our quick legal disclaimer here. As you know, I am a lawyer as well as Rob. However, nothing that we say today will be or should be construed as legal advice or counsel. That's for your protection and our protection. If you do have questions during the webinar, please feel free to go ahead and enter them into the chat, and I'll do my very best to answer them as we go along or as we have at the end. Just please make sure that you put it in the form of a hypothetical and don't have it to be factually specific, because we aren't giving legal advice or counsel today. All right, with that and without any further ado, let's go ahead and get started. What are we talking about today? Let's talk about the laws that really affect background screening and background checks in New York. First of all, you've got the Federal Fair Credit Reporting Act. We're going to dig into a little bit, a very high level of what that is, what your responsibilities as an employer are under that statute. Then we're going to talk about the specific laws in New York that may be affecting you. You've got the New York Corrections Act, Article 23A of the Corrections Act. You've got the New York Business Law, which is basically the equivalent of a mini FCRA, if you will, in New York State. Then you have New York State Human Rights Act, and then last but certainly not least, the New York Fair Chance Act. We're going to cover all of those today, and because we have only an hour of time, we're going to move sort of quickly through these. But if you do have questions, please let us know. So if we move to the next slide, what we're really going to start off with is the Federal Fair Credit Reporting Act. This is a statute that is about 40 years old. It was passed in 1970. It has been amended multiple times. It regulates any individual, company, or person who gathers information from what's called a third-party consumer reporting agency. The big thing for you all to know is that this is a federal consumer protection statute. And what that basically means is that it imposes responsibilities on different entities that are regulated. So it imposes responsibilities on you as an end user or employer of information. It also imposes obligations on consumer reporting agencies, the background screening companies that are running the reports. And there are very specific requirements that you must follow and that they must follow when you're going to be getting any information based on an applicant or an employee. The biggest areas for you to know in terms of responsibilities under the Fair Credit Reporting Act for you as an employer is you must have a permissible purpose, and that would be employment. In most cases, you must then get a disclosure consisting solely of the disclosure and also get someone's written authorization. And if you're going to be taking action in whole or in part on the individual, and we'll be talking about this a little bit later, you must follow the two-step adverse action process. A ton of litigation on the Fair Credit Reporting Act. This webinar is really focused on a higher level on New York specifically, but employers in New York need to understand that they do have the obligations under the federal law as well. The next thing we want to talk a little bit about in terms of an overview before we get really deep into the weeds of New York specifics is the New York Fair Chance Act and an overview of this law. So this law actually was passed in 2015. It was amended very recently in 2021 in July. What you need to know is that it covers any employer who has at least one employee in New York City and at least 4 employees, generally speaking. It has been broadly interpreted now that it impacts not only employees, but also applicants interns, freelancers, independent contractors, including gig economy workers. So if you are in New York City and you are hiring individuals and or you have employees or independent contractors or gig economy workers, then this law potentially is going to apply to you, specifically to individuals who are living or working in the constructs of New York City. This law, it's interesting because the New York Civil Rights Commission has really been interpreting this law and has been very focused on criminal history for applicants or employees in New York. And basically the reason being, and sort of the philosophy or policy reasons behind this, is because the idea is that the New York Human Rights Commission believes that there may be discrimination done by employers to the extent that they take action based in whole or in part on criminal history. So the issue in terms of New York City Fair Chance is that you need to understand that anything related to criminal history, anything related to telling someone that there will be a background check or that criminal history will be reviewed or asking about criminal history is strictly and utterly prohibited until and unless there is a conditional offer. What does that mean? It means that your job postings cannot have any reference to a background check. It means that they can't have any reference to criminal history. It means that your applications, your interviews, anything, regardless of where it is or when it is, cannot be mentioned prior to a conditional offer of employment. So no questions. You cannot, as an employer, go and get Google searches or public record searches or social media searches, regardless of whether it has to do with a third party or not. Remember, the Federal Fair Credit Reporting Act only applies when there's a third party. New York City Fair Chance Ordinance is much broader than that. The other thing that you need to know is that you can, and this is where it gets a little sticky, you can have people first language. What does that mean? You can have something in your application that says, for example, people with criminal histories are encouraged to apply, but be very careful. We call this the no good deed goes unpunished. Because if you say something like, criminal histories will be reviewed on an individual basis, well, that is mentioning criminal history, and that would be a per se violation. It has to be an affirmative offering that perhaps you were encouraging people with criminal histories to apply. And so I will tell you, it is relatively risky to say anything. The general recommendation, and again, we're not giving legal advice today, is that you don't ever say anything about any criminal history whatsoever or background check anytime prior to a conditional offer of employment. We are going to talk about the exceptions in a few minutes, but there are some exceptions for when this law would not be applicable if, for example, there is a specific requirement under federal or state law that you must run a background check. So, for example, perhaps if you are federally regulated or regulated by another law where you must have that information. But be very, very careful. You can have a law that requires you to get information, but you still must comply with with the New York Fair Chance Act. So be careful about that.
Pam, and I can jump in here potentially. Can you hear me?
We can hear you, Rob. Welcome.
Well, thank you so much. So if we can go to the next slide, that would be great. So the New York City Fair Chance Act has multiple nuances to it on a variety of topics. So, for example, non-convictions and pending criminal charges require special handling in that non-convictions and certain pending criminal charges cannot be considered as part of the employment process. Inadvertent and unsolicited disclosures, there is a certain handling of those that is regulated. For example, in the event of an inadvertent disclosure, an employer would not be liable so long as the employer does not ask further questions. And we'll drill down on that requirement a little bit more finally in a few moments. Falsification, situations where an employee or an applicant lies about their background, can be the basis for a revocation of a job offer or a promotion offer. However, even though a falsification is an independent grounds for an employment action, the act of the lying itself, not the content of the background check, the employer still has to follow the Fair Credit Reporting Act. And it's just noteworthy to point out that the New York General Business Law, Section 38GD, requires that a CRA must notify an applicant, and an employer must send a copy of an Article 23A notice if there is negative criminal history that is being reported.
Great. And
one more,
there we
please.
go. Perfect. All right. So what does this really mean? So now we've got this law that really talks about the fact that you've got to, you're prohibited from asking about or looking at anything as it relates to criminal history unless and until you have a conditional offer. Well, what happened back in 2021 was that the term conditional offer really got interpreted to be different than it was previously. So everybody generally thinks of a conditional offer when you give an offer, whether it's in writing or verbally, to an individual that says your offer is conditioned upon successful completion of a background check. Well, what the commission did in 2021 was say what we mean when we talk about a conditional offer is that it can only be conditioned specifically on the criminal history only, or on, they have a call out for ADA medical tests. But really it is conditioned specifically on criminal history only, which would include MVR or driving records under the commission's viewpoint. Interestingly, we've talked to the commission, Rob and myself have both had multiple conversations, and their view is that other things like, for example, OFAC lists or, sanctions watch lists are not necessarily criminal. And so they must be done beforehand. So what are the options? The issue really is you've got sort of two options when you're conducting background checks in New York City. You can have a two-step process, like a bifurcated process, and we're going to talk about what that means. Or you can do everything at once, but you have to segregate that information and hold it back. And it is on you as the employer to have that, really to prove that you didn't have access, that you didn't look at, that you didn't see the criminal history information, unless and until you basically looked at everything else. So the idea is that you need to have a bifurcated process and clear all non-criminal components. What does that mean? It basically means that you're going to do a one-step background check where you are running everything other than criminal. So if you're running, if you're doing a drug test, or if you're running education or employment verification, if you're running credit, if you're running, reference checks, if you're running OFAC, if you're running any other item other than criminal history and or MVR driving check, then you have to do that in this bifurcated process first, and you have to clear all of that information. So what's interesting on that is you make a conditional offer. Again, you basically have to say to the person, listen, before we give you an offer, we're going to be running these first set of checks, and you can't mention anything about criminal. And the problem is, in that perspective there, in this day and age with competition for employees, it's very challenging to do so. The other thing is, when we talked about before under the FCRA, you have to have a standalone disclosure consisting solely of the disclosure, and it has to be clear and conspicuous. So what does your FCRA form say? What does your disclosure form say? Well, generally, if you're going to do a two-step process, the first is going to say, we're going to be getting information about you consisting of, and you list the different checks that you're going to be getting. The problem is you can't say criminal if you're not getting criminal at that point. So you do your one-step form, you have all of the information, you clear everything, education, you do employment, etc., maybe the drug test. Then that person is given a conditional offer of employment, conditionally offered solely on then the criminal history, and then you do a secondary set of FCRA forms that say criminal history only, and you run the criminal background check. that because this is so complex, the question is going to be, well, could you just have one set of forms? And the regulations basically in New York say, sure, you can just say you can just say consumer report, not mention criminal history, and have one set of forms. We believe that that's going to be relatively risky, because while you would be potentially meeting your obligations under New York law, you might be stepping and getting into some sticky areas with potential liability under the federal law. So that is, it's a challenge. What a lot of companies are also doing, frankly, is in New York City, they are not running these other checks or not running them through a third party, because they're either saying, forget it, we're not going to run education or employment. It's not necessarily necessary, although obviously it's a best practice. But in certain jurisdictions or certain jobs, you may not want to do that because you can't do the two-step process in that situation. The other alternative is to do what's called a segregation of information. And so this is sort of a makeshift two-step process. And so at this point, what you would do is you would order everything at once, but you would segregate the information. You would ask your background screening company not to provide you with any of the criminal or driving information until you have reviewed, looked at on a separate report, all of the non-criminal information past that person, for example, and then and only then can you get access to or be given the criminal and MVR information. The key here is it's very hard to prove up that your decision makers or that you will only have access to this information after that conditional offer is made. And that certainly is a burden of you of proving how that system works. There certainly could be the FCRA issues, as we talked about before, about which forms you're using and whether or not they are going to be adequate, being clear and conspicuous depending on what language you are using or not. And again, you as the employer bear the sole burden of proving up that you didn't have access to this information and that it was really a segregated information, that you didn't use criminal history in making the decision. Let me step back for a second and say the reason why this interpretation, or we believe this interpretation, really came to fruition was because we heard from the commission that they didn't believe employers, that they thought employers were running criminal history, and instead of doing the individualized assessment requirement that you'll see the analysis in a few minutes, and instead of providing all of this analysis, they were basically the idea is that employers were using criminal history, but they weren't giving employers the benefit of the analysis, and they were coming up with another reason, for example. So if you've got, employment and education and a drug test and criminal all together, that perhaps an employer was saying, oh, well, I'm really taking action based on your something other than criminal, so I don't have to do the analysis. What we heard from the commission was that they frankly didn't believe that employers were doing this correctly. Therefore, they interpreted this to say, we're going to prohibit you, and you're not going to be able to do it unless you have this bifurcated or the segregated process. The other thing is that, one of the things that we've seen is getting criminal records in New York. It can be challenging and very expensive. So there's different types of checks all over the country. There's a huge industry problem right now with certain court systems restricting access to information. In New York, they have a unified court system that's tremendously expensive. And so I would tell you that, it's $95 per name search. And sometimes, sometimes there's a delay, although usually it can be obtained. But you need to understand that it does become expensive. So that's something that, the whole industry is dealing with. And I'll pass it back to Rob to talk a little bit about some of the things that can be used and cannot be used as we go forward with the nuances of New York. Rob?
Sure. Thank you so much, Pam. Let's talk about non-convictions for a moment. Non-convictions under the Fair Chance Act cannot be asked about or considered as part of the employment decision. So what are non-convictions? Non-convictions under the statute are defined as criminal charges that have either been adjourned in contemplation of dismissal, terminated in favor of the individual. So, for example, the case was disposed of and the defendant had won, adjudicated as a youthful offender, or resulted in a conviction for a violation, non-criminal offense, or that were sealed. So it was either started off as a misdemeanor or a felony and was pled down to a violation, non-criminal offense, or the records were sealed. Any of these types of criminal records that are uncovered through the court system cannot be utilized by an end user and an employer as part of their decision-making process. And the New York City Commission, in explaining this concept and explaining the general prohibition on non-convictions, provides a list of such convictions that's specifically tied to the New York criminal codes, as well as sample language to avoid soliciting non-convictions. Now, what's noteworthy is employers that are operating in New York City or New York State, for that matter, it is relatively helpful to have that explanation from the New York City Commission, but they do note that if an individual has a criminal history from a jurisdiction, the same requirement applies for equivalent types of situations. So, for example, something that's listed on the list of non-convictions under New York law would be treated similarly if it was a non-criminal offense in New Jersey or Pennsylvania or any other state in the union. So that would be treated equally.
Thanks, Rob. The other thing that we see a lot is what happens when an applicant reveals their criminal history without being asked. So let's say you go through the entire process correctly. You have a bifurcated process. You have taken off all of any references to criminal history on anything, on the applications, on the job posting, that you don't ask in any interview. And let's say you're in the middle of an interview and there is you've taken this good faith effort to exclude any reference or asking about criminal history prior to conditional offer. You show, good faith that you have done this. And then all of a sudden somebody blurts out in the middle of an interview, well, I just want to let you know that I've got this criminal history. Is that going to exclude me? And so, the key is to train your managers, to train your HR, to train your hiring managers and your recruiting to understand what to do when you've got this inadvertent disclosure. And really, the best practice in that situation is to tell the individual, we do not consider any criminal history unless and until a conditional offer is made. And then you change the subject. Now, obviously, the conditional offer hasn't been made yet, and you're mentioning criminal history, which is a troublesome area. But if you did not bring it up and there's an inadvertent disclosure, it's very clear to make sure that you indicate to the individual, just so you know, we do not take this into consideration unless and until a conditional offer is made, and then you move on and you change the subject to anything else. Now, is it a he said, she said? Possibly, but it's really important that our folks are trained not to dig. Right? We're not going to be digging in and saying, please tell me more about that criminal history. Well, we'll give you a chance to explain all of that. It's a situation of we absolutely do not consider anything related to criminal history unless and until a conditional offer is given. We'll get back to you on that. Let's go forward and then you move on.
This is one of my, I don't want to say favorite slides because, all of these slides are my favorite, just like my children. But this is where it's a little bit interesting. So I think conceptually, looking back in history on how this issue is handled, how do employers deal with an applicant or employee lying about their criminal history? And I think traditionally the analysis typically would look at a separation between a decision based on the actual criminal history and a decision based on the fact that somebody was dishonest. So, in effect, the cover-up is worse than the crime. No pun intended, although slightly intended. So, with intentional misrepresentation, the Fair Chance Act, when it was amended in 2021, the City Council and the Commission on Human Rights fleshed this out quite a bit more. Now, the key word here is intentional misrepresentation. It's not just a white lie, and it's not just to be kind of candid about it, somebody that just doesn't appreciate the legal process or has a misunderstanding of what happened or misstates something accidentally. What we're dealing here with is the Fair Chance Act's sort of regulation of this entire area and the focus on what does it mean to be intentional. So in order for something to be intentional under the Fair Chance Act, it has to be made with the knowledge that it was false and with the intent to deceive. Meaning, in effect, the person has to know that they're saying something that's untrue with the purpose of misleading the person that's listening, misleading the employer into believing something else. Something along the lines of, you know, it wasn't me, that wasn't the crime, this didn't happen, or any of the sort. To disqualify an applicant, the employer really has to follow a relatively specific process. In order for it to be deemed intentional and to go through that process, and this is independent of what we're going to talk about in terms of the adverse action process, this process that we're about to describe really only deals with catching someone in a lie. So what happens then? The employer has to provide the applicant with a copy of the information that shows the misrepresentation. In other words, if somebody misstates what the offense was, well, we have a document perhaps that shows what it actually was and how it's inconsistent with what the applicant said. If the applicant said a different date, same thing. The criminal background report might contain the information that shows that there's an inconsistency with the applicant. And at that point, once the applicant is given the information, the applicant is granted 5 days from receipt to respond to that. So they can come back and explain, I messed up, I didn't understand, or some other explanation. The applicant, once they give that explanation, the commission deems that if the applicant credibly demonstrates that there was a misrepresentation without any intent, or that it was in fact true, that information cannot be used to disqualify that applicant. So, for example, an applicant is caught in an inconsistency and they come back and say, sorry, made a mistake, I misunderstood, I didn't understand a question, or any of the sort, that basically nullifies whatever the misrepresentation was. Now, presumably, if the applicant comes back with no explanation or says, hey, you caught me, then the employer may be on more solid footing to take some sort of adverse action or withdraw an offer. But in order to get to that point, that process has to be utilized, that 5 days has to be granted, the notice has to be granted, and the employer is no longer in a position to be able to say, listen, it doesn't really matter what the criminal background check said, you were lying and we're taking action. This new process, or now it's about 1.5 years old, this process has to be utilized in order to act upon something that is false and an intentional misrepresentation. So this process applies to that, the intentional misrepresentation context. Pam, let's move on to the next slide and talk a little bit about the adverse action process as it relates to a conditional offer.
Great, thanks, Rob. So under the federal law, there's a 2-step adverse action process under the Fair Credit Reporting Act. That's also no different as it relates to what you have to do if you are in New York. Now, this is going to be both if you are in New York State or in New York City, and we're going to talk a little bit about the differences here. But if anyone who's in New York, if you are going to have a conditional offer, and now it's conditioned solely on, right, it can only be revoked if one of 3 things. 1, if you get criminal history information and then you do the analysis with the fair chance process. We're going to talk specifically about what that fair chance process is, what factors you need to look at, what forms you need to fill out, and what information you need to provide to the candidate. Or the conditional offer is made, it can be revoked if it is based on an ADA compliant medical exam. Going to be pretty rare that happens, but that is one exception. And then the last is only if you get information that the employer could not have reasonably known before making the conditional offer. Again, that is going to be rare, and it's not, for example, generally going to be one of those things that we told you that we would bifurcate. So it's generally, someone's employment history, you're going to be able to generally know before the conditional offer, perhaps they'll accept current employment. So let's say you give the conditional offer and somehow later on in the process, you find out that the person's current employment that you did not check because you couldn't check because the person was still employed there was falsified. Well, that would be an exception. Another exception that we've sort of seen is, if someone is given a job and they are currently in school and they have to graduate, well, you're not going to know if they've graduated, perhaps until, months later if they're still currently in school. That would be an exception. But these are really the rarities. And so more often than not, you are going to need to be looking at the criminal history because now everything else has been passed. You're looking at the criminal history. So what do? The fair chance process, specifically in New York, requires that you provide the individual with a copy of everything and anything that you considered. So that would be obviously a copy of the background report or consumer report. That's also required under the federal law. Any internet search results, if you did Google search, if you had a conversation with the individual, a summary of that conversation or a summary of a conversation with someone else. So for example, if you got other information from someone else, you would have to summarize that conversation. Then you have to provide a copy of the fair chance analysis. And we're going to go in great detail in the next couple of slides about what that fair chance individualized assessment requires specifically in New York City, because there's specific factors that you must look at. We'll talk about that in more detail in a few slides. Then you must allow a specific period of time. Now, under the federal law, between the pre-adverse and the adverse action letter, basically you have to have a reasonable period of time. Now, the Federal Trade Commission has opined that that's 5 business days. In New York, now it is also 5 business days from receipt. It used to be 3. They've now changed that, but it's 5 business days from receipt. So the question is, well, how do you know when the person actually got that information? If you mail it, you may or may not have any idea. So, generally, we recommend that you have some sort of methodology that you give to the applicant that you understand when they've received that, whether you hand it to the person, whether it's electronically provided and you can prove that, or you have some sort of, registered mail, certified mail, or other tracked mailing service, FedEx, UPS, etc. So you need to understand that you have to give those 5 business days. For current employees, they can be placed on unpaid leave during this time frame. You definitely want to make sure that that you provide that time though for them. And then finally, if there's mitigating information, as we'll talk about, you're going to need to do a re-evaluation. So what in the world is this fair chance process? It's a very detailed process, and you've got both what's required under New York State and then what's required under New York City. So let's talk about New York State for a second. New York Article 23A of the Corrections Law specifically talks about all of these different factors that you must look at if you are in New York State, so not New York City for this point. Things like, it's the public policy of the state of New York to encourage employment with people that have convictions. You have to look at the specific duties and responsibilities of the job, how that job and the duties and responsibilities bear on the criminal offense. So for example, if a person is going to have access to, unfettered access to financial information, maybe a theft conviction perhaps would bear more on that ability to perform the duties or responsibilities of the job than, for example, a DUI. If somebody's not driving and they have a driving conviction, maybe there is no relation. You also have to look at the time of the occurrence of the criminal offense. How long ago? How old was the person? Were they 18, 19, 20, or were they 40 and should have known better? And how long was that ago? The seriousness of the crime. Was it a misdemeanor? Was it a felony? Was it a crime against a person or a crime against property, for example? Any information about rehabilitation or good conduct, then your legitimate interest in protecting property and safety. And obviously, if someone, this is very specific to New York, if someone gives what's called a certificate of release of disabilities or good conduct, that actually creates a presumption of rehabilitation. So if you get that, basically it's going to be very hard for you to consider that conviction in making and taking an adverse action. So that's the New York Article 23A factors. If we can go to the next slide, the additional factors that you have to take a look at, is some of these other sort of pieces under the Fair Chance Act. So you'll notice that they're very similar, if you will, to the Article 23A factors, but these are really the Fair Chance Act for pending criminal cases. So pending criminal cases, let me just talk for 1 second. These are cases that are someone has been arrested, they have been charged. So a little bit different than just when someone has a conviction, which was the earlier slide. Pending are the absolute hardest things to deal with. I would highly recommend that you call your lawyer when you're dealing with pending records, because remember, somebody is innocent until proven guilty. You still have to do the factor and the analysis, and you still have to send them the fair chance form, which we'll talk about in a second. The biggest difference on this one is the fourth bullet, which is whether the person was 25 years or younger at the time of the occurrence. So that's a little bit different than you saw on the conviction slide. So if somebody has a pending crime, you actually have to take that into consideration as well. So now let's say you've looked at these analysis and you've looked at all of these different factors. Well, what do you have to do? If you are in New York City, if you're in New York State, you have to look at these factors, but you don't necessarily have to provide a specific form or documentation. If you are in New York City under the Fair Chance Act, you do. Basically, it is a very specific, detailed, challenging form to fill out. It does not have to be the exact same form. It can be substantially similar, but query, why would you use a different form unless you use that same in a different format? It really should be sent at the same time as the pre-adverse action letter in all but most almost all cases. You can send it after, but it becomes very challenging, and it becomes a little bit of a bad experience for example, for the candidate. So consider that recommendation really is, as best practice, to send it at the same time of the pre-adverse action letter. You have to have a thoughtful analysis of the particular circumstances. And all of the factors that we just went over are identified very specifically in that form. And the biggest here issue is, stepping back a second, is when you're filling out this form, you're really only able to take adverse action only if you can look for a direct relationship between that criminal record at the job and that fair chance factors show and support that, and that they don't lessen that relationship in some way. And again, what you're really looking at from when you're looking at all these factors is, does the criminal record specifically create an unreasonable risk to person, public, or property after your analysis? You then have to provide that information to the individual and give them the opportunity to respond. If they do respond, you need to take that information into consideration prior to making your final and ultimate adverse action, which again has to be at least 5 business days later after the person receives it. You have to do the analysis, and then and only then can you take adverse action. Because I have a lot to cover, I'm going to go ahead and we're going to go to some of the exceptions, and we'll go quickly through some of these other areas before we get to questions. Rob?
Absolutely. Thank you, Pam. So real quick on temporary staffing agencies, I know we just passed through the slide real quick. Effectively, with a temporary staffing agency, 2 sets of background checks. The temporary staffing agency can run their own background check to put an applicant into their database, and an employer client of the temporary agency is entitled to run their own criminal background check that's a little bit more job specific. You'll note, just to kind of reference what Pam just discussed with adverse action, a temporary agency may have a different analysis pertaining to a criminal background. An employer client of a temporary agency may have their own and still different analysis as to what some of those factors are and how they play out that are a little bit more job specific. Pam, I'm happy to turn it back to you for a couple of the exceptions.
Thanks, Rob. Yeah, we've got some specific exceptions, and people always ask us, well, wait a second, I don't understand. Does this Fair Chance Act really apply to me? It seems to be extremely burdensome. And the key is, you need to understand, if it does conflict with governing law, you have to really understand, are you prevented from actually complying with both the Fair Chance Act and your obligations under federal or state law? There's some, analysis of whether you are federally regulated. If you you must, for example, get someone's criminal history prior to determining whether or not they're qualified under regulation. So maybe it's maybe you're financial industry, maybe you're in the education industry or other regulated industry. I will tell you that oftentimes, unless and until you are preempted, and that's a question that you really need to get legal counsel on, most employers can comply with both. So you need to understand that as well. And the only exception really would be if you are specifically required to run a check prior to conditional offer. Going to be exceptionally rare, and we're hardly ever going to see that. Like I indicated, if you can still follow the Fair Chance Act to the extent that it does not conflict with the governing law, then you really need to do that. So understand that. And so, let's say it's a licensing requirement. Well, you can still do a licensing requirement after conditional offer. And so again, you have to make sure that you understand what law you are specifically looking at. Again, it's really going to be a federal regulation more often than not, could be state, but you really want to make sure you understand what you're looking at here, because more often than not, you're going to need to comply with both.
Perfect. Let me just chime in a little bit, Pam, with some of the record-keeping requirements and other requirements that happen under the Fair Chance Act. So, for example, in the event of an adverse action, follow the process, revoke the offer, there is a record-keeping requirement under the Fair Chance Act, including for exceptions to this. So if we're going to utilize an exception to that process, the Fair Chance Act and the Commission require that we keep a record of that for 3 years. The criminal history is to be kept separately, where only people who are making the decisions have access. So those two usually do not get intermingled with a personnel file or any of the record-keeping requirements at all. And talk about a couple of the what I would consider some of the easy pitfalls. And by easy, I mean these are listed as per se violations under the Fair Chance Act, which effectively means this is a do not collect $200, go straight to jail kind of a violation. On its face, it is considered a straight up violation. The Commission does not really offer any defenses to these types of offenses. So the first one, and this happens from time to time, especially in other jurisdictions, where we have a job advertisement or a job ad somewhere that says something along the lines of no felonies, background check required, must have a clean record. As Pam mentioned earlier, the guidance on this has been refined a little bit to permit for employee first, quote unquote, language. But generally speaking, any mention of a criminal background or a background check or a criminal requirement or prohibition is going to be deemed a per se violation. Early on, when this act was passed in 2015, in its first iteration, we saw a wave of lawsuits that basically saw applicants or people out in the world trolling the internet and looking for job ads. And once they found them, they'd send one in and say, "Hey, we have you on a per se violation." So that's first and foremost one of the early per se violations that is key to keep in mind. Another per se violation is any inquiry into a criminal background prior to a conditional offer, even if there's no adverse action. So it's someone that went through the interview process, hired, no issues, comes out that there was an inquiry into their criminal background. Now, inquiry, interestingly enough, it's not just asking them face-to-face at an interview or over email or over the phone. It's not even asking the person directly. That may include things like Googling the person. That may include things like asking around or calling someone that in common. Those may be violative of this per se violation. Number two, withdrawal of a conditional offer without following the fair chance process. In other words, despite our comments here today, and despite the fact that we're drilling down on the fair chance process, the form that has to be filled out, the factors that have to be considered, Article 23A, instead a conditional offer is revoked without following any of that process, that will be deemed a per se violation. Another one is an adverse action based on a non-conviction. We noted earlier that there's a prohibition on considering non-convictions. There's a list of examples. There's guidance as to what falls into that. Taking an adverse action based on one of those would be considered a per se violation as well. And the last one that we'll mention is before a disqualification based on an intentional misrepresentation, not following the process, the two-step process, including providing a copy of the information to the employee that we had discussed earlier. So these per se violations tend to be relatively straightforward issues for compliance. We can talk a little bit about enforcement. What we have seen over the last 8 years or so is that the New York City Commission is relatively vigorous in its enforcement. I don't necessarily want to use the word aggressive, but this is definitely a top-of-mind topic. Civil penalties are assessed. Usually they're based on the severity of the violation, the existence of other violations that may occur. Repeat offenders, as you may imagine, are treated a little bit more severely. Employer size, companies that are smaller, 4 to 9 employees versus over 50 would be treated under, would be weighed differently. And whether the employer should have known the law in that factor, a lot of times the commission takes the position everybody should know the law. So that is certainly a factor. But if there's evidence that that specific violation, whether keeps coming up or something like that, that would be an exacerbating factor. The commission has jurisdiction to assess penalties for a negligent violation of up to $125,000. Willful violations are up to $250,000, in addition to other remedies that are available to the individual employees, for example, back pay, front pay, emotional distress, punitive damages, and attorney's fees. Notably, this Fair Chance Act is a component of the New York City human rights law. That law permits civil action in court, as well as the full penalty of civil damages that are available. Aiding and abetting liability warrants a little bit of a call out. This concept effectively applies to anyone outside of the employer-employee context. So, for example, if you have whether it's a CRA, a temp agency, another company that's involved in the hiring process that is involved in whether it's the criminal information, whether it's the obtaining of a background check, the New York City law at issue, New York City human rights law, permits for aiding and abetting liability as to other companies and other individuals, other people that can be sued under this law as well. Let's move to the next slide and talk a little bit about a new development under New York City law that we're watching closely. New York City has passed, and is in effect, although enforcement has stayed, so-called Local Law 144, which regulates artificial intelligence, which under the law is termed automated employment decision tools. We call this out because this concept of regulating automated employment decision tools is being defined very broadly to apply to any computational process that involves machine learning, statistical modeling, data analytics, and is used to substantially assist or replace discretionary decision-making. We call this out because at times this definition has fluctuated, and it's unclear as to whether this might apply to certain processes that are involved in the background check process. It's a little too early to tell. The rules that are being developed are in the works as we speak. There was a hearing recently. Feedback was provided. We're watching this very closely. It is an important topic in which to stay tuned. Let's move to the next slide, please. So, distilling a lot of the concepts that we've talked about today, there are a couple of things that we call out as far as compliance considerations. For example, Pam spent a bit of time talking about the bifurcated process versus segregation of information. There's no one-size-fits-all solution. We have our preferences on the legal side, but a lot of times we have to factor in things like business needs, the burdens, compliance, risk tolerance, multi-jurisdictional considerations in making that determination. things that we use to fine-tune the process. Pam mentioned earlier, certain companies, certain employers are drilling down and being thoughtful about what information do we need, what information is available, do we have an exemption, how do we manage this from a compliance standpoint. Compliance with certain requirements, as far as forms, job ads, we just talked about per se violations, communications with an applicant, how do those happen, best practices for the notice at the pre-adverse and adverse stage, record-keeping requirements, training requirements of human resources and frontline managers, very important for compliance purposes, as well as keeping track of our artificial intelligence developments. I'll kick it back to Pam. I know that we're running short on time. Pam,
Sure.
What do we have to end on?
Yeah. So look, I mean, the key hit here is if you've got a situation, whether or not you have a chance, whether you have an intentional representation, inadvertent disclosures, make sure you understand what the law requires. We were looking to see, I hadn't seen any questions come in. We've been trying to get recently, but we've been trying to get the ones answered as we've been going along here. What I would tell you is this is a tricky area. Really tricky area of the law. You need to make sure that you get, you work with partners who understand this. If you have any applicants or employees in New York or New York City specifically, make sure that you understand where you're going here. And with that, I think I don't see any questions. I'm going to turn it over to our wonderful sponsors to see if they've got any closing thoughts. And thanks everyone for the opportunity today.
Oh, thank you so much, Pamela. Thank you so much, Chip and Saifarth Shah for this valuable presentation. And thank you everyone for joining us. You can view this webinar recording on our website by visiting prestigepeo.com/webinars. If you have any further questions, you can also reach out to your HR business partner for additional guidance. As always, we appreciate your feedback, so please feel free to share your opinions on today's presentation so that we can continue to develop webinars with the information that you and your employees need the most. Be sure to check your inbox for our monthly Insights newsletter, which will give you the latest HR news information you need. You can also follow us on Facebook, LinkedIn, Instagram, and Twitter for current happenings at Prestige and the latest information. Listen to our podcast, HR in 15, for information-packed episodes in a bite-sized package. And finally, remember to download our Prestige Go mobile app for access to your benefits information and support from your HR team members on the go. Thank you all, and we'll see you next time.